Hello, I'm Kendra Yoch. Welcome to the Education Law Insights podcast, brought to you by Franczek PC. Education Law Insights provides you with insight into the latest education law developments and analysis of pressing legal issues in the education field. Today, I'm looking forward to talking with my colleague, Jennifer Smith, about Title IX investigations involving LGBTQ plus parties. These investigations present some complex issues, and Jennifer can provide us with helpful insights. So welcome, Jennifer.
Great. Hi, Kendra. How are you?
Good, thanks. So happy to be talking today.
Yeah.
So to start us off, Title IX prohibits harassment regardless of whether the complainant is male or female, the respondent is male or female, regardless of sexual orientation or gender identity of the parties. So what are the key issues? Why is this different? What should Title IX coordinators and teams be thinking about when there are reports of sexual harassment that involve LGBTQ plus individuals?
Sure. So there's some definitional issues that school districts should understand. So Title IX, new Title IX regulations, they're not that new now. I guess we're 2 years in, but the Title IX regulations, they adopt some very technical criminal definitions. For example, when you're in forcible sexual assault and so what those types of assaults, what it specifically might look like, what the facts might look like. First of all, it's important to understand the definitions, understand maybe your options when you're looking at defining some of the terms where you have flexibility, thinking through what are the best definitions for your community that accurately describe to people what is prohibited in a way that they're going to understand, since the actual regulation, the language is so legal, so that's one issue is first of all establishing what are the definitions, what do these things even mean, what do they look like for different populations, so that we can identify, is this sexual assault, is this harassment, or is it something else, is it going to fall under one of our other policies? Generally, I find administrators are very good at, they know like this is wrong in some respect, but which during some of our trainings we have like a fork in the road, which path am I taking here, which procedures apply, and so understanding the definitions will help you pick your path in the road and make sure that you've complied with Title IX if that applies to the situation.
So let me ask you a question on that before we go on to the next issue. And so do schools and institutions, they have some discretion in how the language they use to describe, what is sexual assault, what is rape or fondling, and exactly how those things are defined and listed out?
So some, I mean, and it depends on the terms. So some of the terms are, like I said, they are defined within Title IX. Some of the terms, and one key one, for example, is consent. That is not defined, and it's specifically referred for the local institution to define. And that gets, the issues are not necessarily intuitive as to how even an issue like consent. So are you going to define it broadly so that more behavior is covered by Title IX? In some ways, that initially, I think that is sometimes the thought is we want to be really protective and protect our students of, conduct that's not appropriate. And so we want to be really clear and broad in our definition of consent so that it really, it's locked down. Now, the problem with that, and you and I know that in some ways these Title IX procedures are not helpful to the institution and not helpful to the parties. So sometimes you think, well, should we define a term more narrowly so that we can use our other procedures? But of course, to some who don't understand the issues, that may look like you're trying to give loopholes or not address, certain sexual misconduct. And actually, it's the opposite. So it requires some community. If you're going to go that kind of route, it requires communication in your community and understanding of we're helping and we're helping the cause, so to speak. We're protecting our students more in some instances by giving them access to our non-Title IX policies for certain situations. So that's where I just mean be intentional. Now, sometimes maybe it's fine for Title IX, Title IX to cover, and we decide, no, the confusion that would be caused by trying to sort of thread that needle is not helpful to our community. And so we're going to kind of play it more straight up the middle in terms of define it the way you want consent to be defined and understood in your community, and not do any gamesmanship with trying to exclude certain things to get it into a different bucket of sexual misconduct where Title IX would not apply. So I know that that sounds murky, but that's one example, and of just making sure, if you're responsible for Title IX, that you know what decisions you've made in your school and understand how that plays out, so that when these situations are in front of you, okay, this is the decision we made with our policy, so I understand it's going to apply in this way. And you're not stumped in those situations where something falls in a gray area where maybe you could have made one choice or another about your definition.
Yeah, I think these issues are sometimes surprisingly complex. Things like definitions and making sure that you have them clearly defined in the way that you want, and you've thought through the way that that's going to play out. And then that your whole team knows where to find it, right? That the investigator knows this is my procedure and these are the definitions, so they know what they're looking for in the investigation, and the decision maker knows what standards to apply. The definitions actually make a big difference.
Yeah. I mean, we're also in this weird time period where new proposed regulations have been promised, but we know that process takes a long time. So it's also a balance of how much perfecting you want to do of your current policies, knowing there's more to come. I mean, in some ways, it would just be an understanding of, I think, knowing what is working and what's not working for you, so that whether it's now and you want to do some refining now, or whether it's when there's new regulations and inevitably you'll have to make changes to align with those, what other issues you might want to take a second look at because of your experiences. I think we're all starting in our office. I know we're all starting to kind of have a list of those issues, like, okay, we've lived with this now, and here's some things if we could do a refresh that we would put on the list.
Yeah, for sure. Okay, so what's the next issue that we should be thinking about with respect to LGBTQ investigations?
So I think confidentiality. It's an issue that is important no matter the status or LGBTQ identity of one of the parties. But in particular, I think it's an issue where you may be outing an individual, either a party or a witness. And so you need to be mindful of, for one, I think just informing the parties what is confidential and what is not confidential, so that there are no surprises, and they make and the parties can make decisions about their disclosures, about the evidence they share, knowing the landscape of what's going to be released and what's not going to be released. As many people know, one of the main criticisms of Title IX is the full disclosure that's required between the parties, and then the direct questions that can be asked if they're relevant. And depending on the fact situation, it's possible that a person's gender identity or sexual orientation, it could be potentially relevant to understanding a situation of harassment or assault, to understand whether in that context something was, severe, pervasive, objectively offensive, and to understand whether something was a sexual assault or met one of the other definitions. So I think that there are situations where it could be relevant, and then confidentiality comes into play because we know that you do have to share certain evidence. But we also know that outing someone is discriminatory, and so
Yeah.
that is, so it's an issue to be navigated. And like I said, I think the key thing is to navigate it by informing parties of what the process is, so that certainly nothing's done by surprise.
Right. And I think the confidentiality issues, I mean, are huge regardless, just across the board, because it is such a change in how schools handle these complaints and investigations. Used to be you could report and say, but I want to be anonymous. Please look into this and try and deal with it without letting anyone know about me. And you may or may not have been able to do that, but now you can't. Right now it is automatically, the complainant is going to be divulged to the respondent if you're moving forward with a formal investigation. The exchange of evidence is just completely foreign, I think, and that's a lot of information to share with the other party in this sort of situation.
Yeah, I mean, it also, I think, is you want to be informed of it so that your investigator designs their questions and at least thinks through the issue. Is this relevant? Is the status of any individual involved, is that really relevant? Does it tend to prove or disprove a certain allegation? Maybe the answer is yes, but if it's no, and then maybe the investigations doesn't need to be as broad and go into certain issues so that it's not part of the evidence file. I think just having intentionality about some of those issues can support a better process and a more supportive process for those community members, even though it's going to be difficult. I mean, the other thing would be, of course, parents having knowledge and being entitled to notice of certain things, so including the allegations. So again, concern about outing students, outing parties is on the forefront there.
Right. And so I guess related to that and supporting, the third issue that you had flagged was supportive measures. And we want to talk a little bit about things to think about on that front.
Yeah, so I think an understanding, sometimes schools have different teams or different experts within your team that maybe is more familiar with the supports the district has for LGBTQ students. And there's often different supportive measures that maybe are specific, whether it's, gender neutral restrooms or access to certain parts of your building, access to certain like counselors or those that have expertise, just a knowledge about confidentiality and, on your team. So making sure that you understand what are our resources, not just for students in general, but also for LGBTQ students who might have specific issues that come up that are somewhat unique, or call on different supportive measures than maybe would be in your typical toolbox.
Yeah, that's great advice. And I think also remembering that, you don't have to file a formal complaint to have access to those supportive measures, which, especially when we're thinking about the confidentiality issues we just talked about. I think a lot of the clients who I've talked to, they have had parties come in and report something and say, but you know what, if you can put these supportive measures in place, I don't feel like I need to go through that whole process. I'm happy just, having my schedule changed and having access to the social worker, and that's going to work for me. And so that piece of it, I think, is good to flag as well.
Yeah, I mean, really, the more robust, I think from a supporting students perspective, unfortunately, much of the process, I think one would walk away feeling a little discouraged that maybe they haven't moved the ball in terms of supporting students, but it's really that supportive measures piece where I think you do see, okay, how can we be creative and meet the students' needs, setting in the parking lot, the issue of whether the allegations are true or not. It really doesn't matter. You have a student who's come to you and clearly in need of some support, so let's focus on that. That can be hopefully a silver lining and a productive part of this required process.
Yeah. Well, thanks, Jennifer. Is there any other issue you want to flag for us on this topic?
No, I mean, we do have a training that goes, is a deep dive into some of these issues if people are looking to help support, their investigators or their decision makers in understanding some of these issues. So we do offer that as a firm, but just glad to have an opportunity to flag it for all of our clients that are struggling with this.
Great. Well, thank you, Jennifer, and thank you to everybody for listening. Do join us again for upcoming episodes about essential education law issues, including updates when we have new proposed Title IX regulations, which we do anticipate in the next few months. I can't believe that's already only a few months until April. And you can sign up to watch our webinars live at franczek.com under events, or keep listening here on the podcast. If you're enjoying the podcast, do subscribe and share it with your friends and colleagues. And if you're looking for more insights, check out our alerts, our blogs, follow us on Twitter and LinkedIn. And thank you for all that you do for students. Thank you, Jennifer.
Thanks, Kendra.